Hello, and welcome to a topic lecture on the March-April Lincoln-Douglas debate topic from the National Speech and Debate Association, which is resolved: the Supreme Court Justices of the United States ought to be term limited. My name is Jet Smith, and I'm the head speech and debate coach at Highland High School in Pocatello, Idaho. And this topic is the state topic for our state, but it's also the national qualifying topic for a lot of different states and for a lot of championship tournaments. So my goal with this video is to provide access to resources to help you get better at speech and debate for no cost, to make things more equitable and accessible. So today we're going to talk about a lot of different things. So we're going to basically have 6 parts to this. We'll talk about the resolution itself and break it down. Then we'll talk about logistical questions that need to be answered in this resolution. We'll discuss the framework or the value and value criterion that tells us what ethical rubric you should give the judges for evaluating your debates. We'll discuss AF arguments or reasons why they ought to be term limited, neg arguments, reasons why they ought not be term limited, and then I'll close with some recommendations and warnings as my final thoughts for this topic. So, first things first, let's analyze the resolution through 5 different things. We have trichotomy, definitions, background, core controversy, and stakeholders. So with trichotomy, the question is the resolution a question of fact, value, or policy? And with this topic, it's kind of an interesting combination of answers. So a policy topic says that an actor should or ought or shouldn't or ought not do something. Value usually is either a comparison, X is better than or worse than Y, or X is good or bad according to Y. Whereas fact topics seek to describe what is or has already happened or predict what will or won't happen. So the short answer is that this topic is mostly a policy topic, but it's written in the passive voice rather than an active action statement. It's kind of a value topic, but it doesn't give you something to explicitly compare it to or a standard to judge it on. And it's hopefully not a fact topic. What I mean by that is that this topic has the word ought and an action. Be term limited as the action, and it has the ought in the motion, but there is no actor. It doesn't say Congress should term limit the Supreme Court. It doesn't say the United States federal government should term limit the Supreme Court. It just says they should be term limited, which means it lacks an actor that is specified. It makes a judgment because it says whether something ought be or ought not be, but it doesn't tell you a standard upon which you can say this is good or bad, or it doesn't say should be term limited rather than something else. The reason why it could be treated as a fact topic is that you could make it about the probability of a future action. So you, in the same way that you'd say, wow, they ought to be here by now, or they ought to be the winner of this debate, like I predict them to win. Ought to can be used as a way to describe what might happen. So some people might see this as, is this a realistic thing? But I think that's the worst version of the topic, so I would not do that if I were you. So next, definitions. There's a couple of different important terms in this motion, again, of the Supreme Court Justices of the United States ought to be term limited. So the Supreme Court Justices, they are members of the highest judicial authority in the United States. They are judges called justices, and there are currently 9 of them on the Supreme Court. Second, ought to be, or to be term limited, means to be restricted on the number and length of cycles or terms in which one can serve in a public office. Be careful though, because most definition cards say elected officials, and Supreme Court justices are not elected. So your term limited definition has to match something that could be applied to a non-elected position. And then lastly, we have the word ought, which has a couple of different ways you could look at it. If you're the affirmative, the best way to look at it is a definition that implies that taking an action is necessary or desirable. So basically, it would be a good thing if this thing happened. Whereas if you're the neg, you have a couple of different sketchy ways, in my opinion, to define it instead. The least sketchy is moral obligation, but the reason why you'd read moral obligation is that it's not enough just to prove that being term limited is desirable. The affirmative has to now prove that it is a moral necessity, not that it is just like kind of, sure, we could do it or not do it and we'd still have morality. Then you have the second one, which is ought implies can, and that is the affirmative has to prove that the Supreme Court justices can be term limited before they prove that they're required to be term limited. So there's some arguments on the topic that imply that it's not possible for the Supreme Court justices to be term limited, or at least it's not probable for them to be term limited, which is kind of the third way of defining it, which is ought implies likely. The affirmative has to prove that it is probable that the Supreme Court justices will be term limited, not that they should. So that's that ought equals likely rather than ought equals, desirable. So probably the best version of the topic is one in which we use the affirmatives definition, and we're kind of just discussing, is this desirable or not? Now, background on this topic is pretty important to understand, so I have a lot of different things to discuss. First of all, the way that you get on the Supreme Court in the United States is that the president has to nominate you, and the Senate has to confirm those nominations. They have to approve those nominations in the chamber. Supreme Court justices serve for their entire life unless they retire, die, or are impeached. And pretty much no other country in the world does this in the exact same way that we do. Now, our Constitution in Article 3, Section 1 says, quote, "The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior," which has been interpreted by most people to mean a lifetime appointment. So how do people get on the court? Well, new justices get appointed when someone dies or when someone retires, and the confirmation hearings in the Senate and the nomination process are incredibly contentious. So some recent examples of that would be Ketanji Jackson Brown, Amy Coney Barrett, and Brett Kavanaugh. So since the Supreme Court was first created, a lot of things have changed. One is that the life expectancy of people has risen. So before, if you got on the Supreme Court at age 40 and you were expected to live until age 50, then you were going to be on the Supreme Court for a lifetime appointment of only 10 years. But now that the lifetime expectancy has risen by a couple of decades, people are serving longer and longer terms. Additionally, there used to be way more appointments every quarter century, like when you look at the average. But instead of appointing 14 justices, so replacing the entire court essentially every 25 years, that has dropped to 8 since 1975. So we are replacing judges at lower and lower rates because fewer and fewer judges are retiring or dying on the court. And then only 5 of the last 27 justices have left the court through death rather than retirement, as opposed to 27 versus 11. So retirement is a way more popular way now to leave the Supreme Court, which has caused a whole bunch of political kerfuffles. So before, this is probably the most important fact to know about the past, is that from 1789 to 1970, the average judge served for 16 years and retired at 68. Whereas now, from 1970 to 2005, that average rose to 25 and a half years, and the average judge was leaving at 79. So people are serving way longer terms and staying on the court into a much later age. Another thing to note is that a third of the justices that are currently on the Supreme Court were nominated by a president, Donald Trump, that didn't win the popular vote. And so a lot of people feel like the Supreme Court's decisions aren't reflecting voter preferences for a lot of different reasons, but that's one of the biggest ones. The most recent controversy that really brought the Supreme Court's legitimacy into the limelight and made people talk about term limiting again was Roe v. Wade, the abortion case being overturned, threatening access to abortion for people assigned female at birth all over the country, but mostly in states in which they individually decide to ban it. So a recent political thing that also happened was in 2021, Democrats introduced the Term Act, which is a way to establish an 18-year single term limit on Supreme Court justices. So that would essentially, enact the topic, but it has not passed and it doesn't look like it's going to. So what is the main issue at play here in this topic? The main issue brought into question by the resolution: is America better off with a Supreme Court that has part-time appointments than with lifetime appointments or some other system for justices? So affirmative is going to say part-time is better than any of the other alternatives, whereas the negative will either say we should continue with what we're doing or propose some other thing. So who is most affected by the resolution's outcome? Well, there's 3 main groups. I would say American citizens, because they are, represented by the Supreme Court and their decisions affect them. Elected officials, because they are the ones who are responsible for, if you're the president, nominating or the Senate confirming, as well as people who are currently on the Supreme Court or who are interested in getting on the Supreme Court are all likely to be affected by the outcome of the resolution. So now that we've talked about that, there are unfortunately a lot of logistical questions that I don't think can be avoided. I know that this is Lincoln Douglas debate and not policy debate, and that technically the resolution is not phrased as a plan. The problem is how the Supreme Court justices are term limited will massively change the outcomes that occur, which will likely change the decision calculus of whether or not it's morally correct to have them be term limited. So you need to focus on 6 different issues about how the term limiting would happen in order to know what effects it would produce to judge the morality of those consequences. So length and time, how often and long would the terms be limited to? What happens to the current justices that are on the court? So would this be applied retroactively to the current justices, or would it only apply to new ones? What happens to judges after their 18 years is up if they are, still alive? And what happens if justices don't finish their terms because they retire before their 18 years are over, or because they die? And legal implementation, how do we put this into law? Would we do it through a constitutional amendment or through statutes from Congress? And lastly, what happens if the Senate refuses to confirm a nominee before the cycle is up? Again, you might be thinking this is LD, not policy. I think you should tell that to the topic committee and coaches and students that keep voting for topics that require you to discuss implementation for it to make any sense. And the affirmative will likely say that because this is LD, they only have to prove the resolution true as a general principle and that they don't have to read a plan or discuss implementation. And while that is technically true, as the negative, you should say, don't you agree that what term limits are implemented and how they're implemented changes why or why not they ought to be implemented in the first place? And then second of all, you should ask in cross-ex, will you defend both the benefits and harms of the most likely ways Supreme Court justices could be limited? The fear of affirmative saying, well, this is LD, I don't have to specify, is that if you read a generic argument against one way that it could be implemented, the most popular way, the affirmative could stand up in a later speech and say, oh, well, we just wouldn't do it that way, to avoid all of your arguments. So you really want to try and nail the affirmative to, if you will not specify, will you at least defend all of the things that could be specified, or the most likely things that could be specified? So first logistical question that needs to be answered is length of time of the appointments. How long and how often would the terms be limited to? So the most evidence on the topic is written in the context of this plan to do an 18-year single term thing. So what that means is that every 2 years, a justice retires and that justice is replaced. So eventually, every president would get to nominate 2 justices in each term that they serve. Because remember, a president serves for 4 years. So they would nominate 1 justice in the first year and another justice in the third year, the same years that these justices start retiring on a 2-year schedule. However, that is not the only options discussed in the literature. Other people say that they should retire every 8 years. Some say 10 years. Probably the second most popular plan is 12 years. And that way, every president would get to nominate a justice 3 times per term rather than 2 times per term. So next is, would the term limit be applied retroactively to current justices? If the answer is yes, then you can replace the current justices in order of seniority. So that means whoever has been on the Supreme Court the longest would retire first, and you make them retire starting every 2 years, beginning in the first year of the very next president. So whoever is president next after Joe Biden's first term, whether it's Biden again or a different person, in their first year, we make the longest serving justice retire, and then we get to replace them with a new one. 2 years later, the second serving, now again, the longest serving justice retires and we replace them with a new one. Under this system, it would take roughly 18 years, assuming that there are no early retirements or unforeseeable deaths, to make a court of entirely new justices. If the answer is no, then what you say is the current justices do not have to apply to this rule, and they will get to stay on the court as long as they live or until they retire. Most estimates say that it will take roughly 35 years to replace the current court and settle at a permanent amount of 9 justices. If you apply the rule to the justices currently sitting on the Supreme Court, you basically make it so that we have to have 9 because you're replacing them every 2 years with 18-year terms. But if you don't apply it to the current justices, then there could be more than 9 justices because we are going to still nominate new people every 2 years. So it could change the number of people on the court. Next, what happens to judges after their term is over if they're not just, going to pass away or if they're not retiring so on purpose? So either you could give the justices an opportunity to serve in other roles for the court to help the court out, even though they don't have voting power, or they could go back down to sitting on a circuit appellate court, so a lower level court beneath the Supreme Court. Or you just force them to retire from serving as a federal judge in general, where they just have to retire. The latter is probably unconstitutional, so unless the affirmative defends changing the Constitution, then it's most likely the first one. Next, you have unfinished terms. What if justices don't finish their terms because of impeachment, retirement, or death? You have a couple of different options. One, you could let the president nominate another justice to finish out the existing or the exiting justice's term. So the president would get to make essentially an emergency nomination, kind of like what the current system is. Or you could invite the most recently retired justice to finish out the exiting justice's term. So whoever within the last 2 years was replaced last, invite them to come back and fill the seat of the justice that is exiting unexpectedly. Or you could just leave that seat empty for the remainder of their term, which might mean that if it was a brand new justice, that seat is empty for 18 years. So all three of these are potential ways that is discussed in the literature of what could be done. Next, legal implementation. How would this actually happen? If they are term limited, what would that process look like? So the one way is a constitutional amendment to require term limits voted on by Congress and or the state legislatures. Constitutional amendments are incredibly rare. They're very difficult to pull off, but because the resolution says ought to be term limited, you can say they ought to be term limited even if it's unlikely to happen, because that would be desirable. Or the more likely way that it happens, but the less enforceable way that it happens, is Congress imposes a statute or a regulation on what the office of being a justice implies and requires, which would just kind of change the definitions that kind of give the Supreme Court their power based on congressional confirmations and nominations. So both of those are different ways that this could be implemented, and both have their problems. Lastly, you have what happens if Congress or the Senate refuses to confirm a new nominee. If the president is supposed to get to nominate someone every 2 years, what happens if the president is from one party and the Senate is controlled by a different party, so the Senate doesn't want to confirm their nominee no matter what? So there are pretty much 4 different things that could happen. One, there could be part of the rule that says the Senate cannot do anything else. They can't vote on legislation. They can't appoint other people to other courts if a nominee for the Supreme Court has not been confirmed yet and it's been nominated. Or you could decrease the threshold needed for votes in order to confirm them. So you could start by saying the first time that the president submits a nominee, it takes 66 votes to get that person on the Supreme Court. Then you could drop it to 60, and then 51, and then 40, and then 34, and those numbers are just made up, but it's the idea of going from a super majority, like 2/3 majority, to a 60 vote majority, to a simple majority, and then to like a 1/3. Like then it basically would switch to, unless 2/3 or more of Congress disagrees, that person would get confirmed. You could also say that instead of the Senate getting to make the decision if they failed a certain number of nominations, instead you take the head justice from the 12 appellate courts to be the new confirmation body, and then those 12 people, those 12 head justices, would get to make the decision for the new nominee instead of the Senate. Or you could just leave the seat empty until the next 2-year period, which could create a really small court. So all of these have their own benefits and harms. So now that we've answered all of those questions, understand that you as the affirmative are not required by the rules to specify anything other than saying that the resolution is true as a general principle. The truth is, though, you want to have an idea of how you interpret that general principle, because if your opponent goes up there and starts saying, my opponent's going to leave seats empty if the Senate doesn't confirm them, and tries to make a whole bunch of arguments about that, you probably do want to be able to say, no, that's not what I think we should do, so that you don't have to bite into that argument. So having an idea and being able to explain what the term limiting would look like is going to be important to painting a picture of it in a positive light. If you can't paint a picture of it at all, it's going to be difficult to convince someone that it's a good idea. So now let's talk about the framework. And the framework is, what ethical rubric should you give the judges to use for evaluating your debates? On the previous topic of open borders, it was pretty simple, at least on the value premise level. The value was pretty obviously justice because it was in the topic. This topic, on the other hand, in my opinion, all 4 major values have a case for being used. So there are 4 different main values in Lincoln-Douglas debate that I think people should stick to. Every once in a while, a topic comes along that opens up another, but really it's these 4. So the value premise is the ultimate ethical principle that judges are trying to align their decisions with on the topic. So the first one that you could do, and probably the most popular one on the national circuit, will be morality, and morality being principles that guide right and wrong. So how did we get to morality? From the word ought. So people will say, because of the word ought, that means that this topic is about moral obligations, so our ultimate goal needs to be morality. And then another option is governmental legitimacy, which is the justification of political power by institutions. How did we get that from the topic? Well, the Supreme Court is a government institution, so it makes sense that you'd read a value about government. Third of all, you have democracy, and that is government of people in a society by people in that society. So by and for the people. So where do we get this from the topic? Well, it's about the United States, and arguably the United States is a democracy, or at least strongly values democracy. The last value that I think is probably the weakest of these four in this topic is justice, which is giving each their due, but technically the judges are called justices because that is their job, to deliver justice. Not necessarily in a criminal sense, but giving people what they deserve based on the Constitution is the reason why they're called that, essentially. So you could argue that justice is the role of Supreme Court justices. So all of these different values could be read on this topic. But perhaps more importantly, especially if you and your opponent agree on the value premise, is how you should best measure the achievement of the value premise. So the value criterion is the philosophical lens for measuring the resolution's achievement of the value premise. And each of these values has at least two options that leap out to me. So for morality, you could use utilitarianism, which is maximizing expected well-being. If you're wanting to go for like a big shtick impact case, this is probably good for you. And then you have egalitarianism, which is respecting people as equals, could be a good way to measure morality. And then your contentions are different ways that the resolution either does or does not respect people as equals. And then you have governmental legitimacy with a couple of different options. You could also probably move some of these criterions to different values. I just put them with the value that made the most sense to me. So on governmental legitimacy, you could do constitutionalism. How do you know if a government's legitimate? If it's upholding its constitution. Contractarianism, which is upholding the social contract, or democracy, respecting majority rule. So all of those are different ways that you could measure the legitimacy of the government, and then your contentions would be examples of why the resolution either does or does not do the criterion. Then under democracy, you have government of people in a society by people in that society. There's a couple of different criterions for this that you could use. And those are accountability, so holding public officials accountable, equality, promoting political equality, and integrity, maximizing election integrity. All of those, you could argue, are central to having a democracy. So that's why we have to measure the resolution through like those terms. And then lastly, for justice, two different ideas. You have structural violence theories, most likely minimizing structural violence. And then you have Hobbes contractarianism, which is about protecting citizens. So you'd argue if the topic protects citizens or doesn't protect citizens or minimizes or doesn't minimize structural violence, then it is true or false or should be affirmed or negated. So now that we've talked about what judges are supposed to be looking for, or what you'll tell them they're supposed to be looking for, how do you meet those ethical frameworks through your arguments on the topic? So first, let's talk about the affirmative side. So reasons why the Supreme Court justices of the United States ought to be term limited. I have 10 reasons that you could turn into contentions on this topic. So the first one is about decreasing extremism. So the thesis of this argument is that term limiting the justices would moderate the court's political leanings. So uniqueness, and remember, uniqueness, link, impact, basic structure of a contention, what's going on now, how would the topic change it, and why does that matter? So for the affirmative, you want to say things are bad right now, term limiting the justices would make them better, and that matters because. The uniqueness is essentially saying that the way that our Supreme Court is set up is that presidents want to select justices that will side with the conservative or liberal, whichever political spectrum they're a part of, on almost every single decision. So they want to pick someone who always votes the same way, which usually means that they're pretty extreme in their opinions. But by term limiting the justices, the presidents won't have the pressure of saying this person could be on the court for the next 3 decades. I have to pick somebody who's going to agree with me on everything. Additionally, even if some candidates on the Supreme Court are extreme now, they will only be there for a maximum of 18 years, and there will always be new people coming in with new ideas. So the impact is that we will have a more moderate Supreme Court that better represents the public and has less extreme viewpoints, which will probably prevent massive overrulings of different precedents and also will narrow the scope of decisions and make them have like smaller, narrower interpretations and thus effects. Next, we have second argument, which is depoliticizing judicial retirements, which I kind of brought up earlier. Thesis of the argument is that if you term limit the justices, you end strategic retirements that lock in partisanship. So right now, justices currently wait to retire until there is the combination of both a president and a Senate chamber that will nominate and confirm someone who will act just like they do once they retire. Which is why sometimes people retire earlier than they otherwise would, but most of the time they wait to retire until the government matches what they want it to. So if you term limit the justices, then they don't get to control who their replacement is, and judges will be more likely to retire if their health deteriorates, because they will stop feeling like, but if I retire now, the person who replaces me will not agree with me. Why does this matter? Well, if you end retirement games playing, then the court's probably going to be more independent of the other two branches of Congress, and it's going to be more politically impartial. It's also probably not super fair that somebody gets to choose their own replacement rather than like the other people getting to choose their replacement. It's probably not very democratic. Third idea is about equalizing presidential opportunity. Thesis of the argument is that term limiting the justices would give different presidents fairer chances to make nominations. So right now, presidents get completely different amounts of nominees depending on the circumstances of the time that they are president. That's because you can't predict when people are going to die. Justices sometimes choose not to retire under presidents they disagree with, so on and so forth. So some presidents only get to nominate one or two people, or maybe even nobody, whereas other presidents will get to nominate up to 3 people in a single term, or even 4 people in a single term, which could be, it's unfair to have presidents at different levels. So the link of how this changes is that if you term limit the justices, you standardize the process, making it so that every president gets to make an equal number of nominations per term. This especially works well if you're defending the 18-year idea, because then it's like every president gets to nominate someone first year of their term and third year of their term. So the impact is that if you equalize nomination opportunities, you will make the presidential power fair across presidents and therefore prevent undue inequality for our country's leaders. Fourth argument is about improving election integrity. Thesis of the argument is that if you term limit the justices, you will improve the integrity of state and federal elections. So right now, presidents could basically nominate, if enough circumstances happened the way that they could nominate enough justices to sit on their own impeachment or election, and the Supreme Court won't vote to protect voter rights. So there could be so many justices that were nominated by that president who were picked to be an ally of that president, and basically that means that there could be a whole bunch of bias in favor of the president, especially when it comes to elections. Or the Senate, if the Senate has confirmed a whole bunch of conservative justices or a whole bunch of liberal justices, those justices from this one single time period are more likely to side with that political party that confirmed them. So if you term limit the justices, then no president will likely get to nominate more than 2 or 3 justices per term. So that says that it will be more fair, so that there will not be so much connection to the president. The more extreme version of this argument that will only work in some states is that if you term limit the justices, you will eliminate the conservative supermajority that currently exists on the Supreme Court. And the fear with the conservative supermajority is that they will always side with conservatives in issues of the elections. So the impact is that election integrity means that people have more confidence in the government, people are going to vote more often, they'll have more representative democracy where people are aligning with their citizens, and there will be less corruption. Fifth, you have improving public opinion. Term limiting the justices would improve the reputation and legitimacy of the court in the eyes of Americans. So right now, Americans don't trust the court or see it as legitimate. Its opinion is the lowest it's been since it was tracked. But if we term limit justices, people will probably like the court more, and it is popular with voters. Pretty much every poll says that the majority of voters, regardless of party, prefer a term limit for the Supreme Court. And then the impact is that the court being legitimate or being trusted matters, because it's the only way to keep them as a check on the other branches of government. And it also means that they will ensure, like, the executive branch will carry out and Congress will carry out what the court says because the public cares about it. Sixth, we have improving the representation of the public. So by term limiting the Supreme Court justices of the United States, we will improve the diversity of the court in both identity and beliefs. This could be one argument, or you could split it into 2 arguments. So first, on uniqueness, what's going on now? The makeup of the court does not really reflect the US population in terms of all of these different identity factors. The justices also really don't represent the beliefs of the majority of citizens. And even though they're supposed to be a branch of government and government is supposed to be by and for the people, they're not really fulfilling that. But if we term limit the justices, then we can have more nominations more often, and we can get more diversity on the Supreme Court. Additionally, the court will be able to have new and fresh perspectives that are coming from like things that the public has realized over time. And the impact is that we will have a more representative democracy. We will probably have less bias, and we will improve the quality of our decisions and improve the legitimacy of the court and public opinion of the court. Seventh argument is about improving the quality of justices that are nominated to and that sit on the court. So if you term limit the justices, it will improve their quality. So right now, nominations are often rushed and unpredictable because we don't know when somebody's going to retire and we don't know when somebody is going to pass away. That means that the nomination process is often rushed and we don't have enough time to really evaluate them because of time pressure. Also, a lot of justices will stay on the court past their intellectual prime as they age because they're supposed to be there for their whole lives and they're too afraid of getting replaced in a way that they don't want to. But if you term limit the justices, we now know who is retiring when, and you know that it's on a standard cycle of every 2 years or every 3 years or something like that. And that will make the process more predictable and transparent so that we can prepare for it longer. There's more time to consider who you're going to nominate, and there's more time for the Senate to be able to evaluate the potential nominees. Justices would retire before their health and skills atrophy as well, which means that they will not stay on the court past their prime. The impact is that we'll have better judges, and better judges make better decisions on crucial issues. They'll also likely be more motivated to work through cases faster and more efficiently, which will reduce the case backlog that currently exists. Eighth idea is about moderating confirmation process. So term limiting the justices would reduce the rash intensity of the confirmation process. Nominations are really, really contentious right now. The parties fight within the parties and also fighting against the other party. It worsens the divide in our country. Political polarization increases during Supreme Court nominations in the Senate. And if you term limit the justices, it becomes less of an active political spectacle where it feels like a once in a lifetime opportunity. And instead it becomes an every 2 years thing, which makes people feel less, insane about it, because it's not like the person we pick will probably be on the Supreme Court for 30 years. It's at most 18 years, which will make it not feel as, life or death, moderating the confirmation process and making people more willing to work with someone across the other side of the aisle. The impact is if we moderate the tensions, we will make our nominees more bipartisan so that everyone can approve them. And it will also help the Senate get back to legislating because it's not going to feel like this crazy thing that they have to spend a lot of time on. It's going to be a very standardized thing. Ninth, we have preventing bad court packing. So if you term limit the justices, it would eliminate the need for and pressure to pack the court with more justices. So right now, and especially since the Roe versus Wade decision, President Biden and even future Democratic presidents for the next probably couple of decades are going to be under a lot of pressure to pack the court by adding more justices, because there's nothing that says that we have to have 9. So a lot of people think that Democrats, in order to flip the majority from being 6 conservative to 3 liberal, at least bring it up to 5 liberal or even up to 7 liberal by just adding more justices, not replacing any. So a lot of people, however, would argue that that is a bad thing to do. So term limiting the justices means that there will no longer be a reason to pack the court, because people can be sure that the court will be totally different within the next 18 years. So it eliminates the call to back the court or to pack the court. And since so many people think that's a bad idea, it would likely take away the pressure. And then impact preventing court packing is essential to the court's legitimacy and fighting political polarization. If you pack the court, it means that the Supreme Court is inherently political, and we're trying to keep it a depoliticized institution. So a lot of people think that court packing is bad and that this is a way to prevent it from happening. Lastly, for the affirmative, you have improving efficiency. Term limiting the justices would increase the rate at which the court hears and rules on cases. So first, under uniqueness, the Supreme Court rules on way less cases now than they did originally. Each year, the number seems like it's getting smaller and smaller. But if you term limit the justices, But if you term limit the justices, they will have a way higher sense of urgency to make a lasting impact in the 18 years that they have. They won't see it as, I have the rest of my career to make these, big decisions. They'll be more, motivated to try and work through cases so that they can make an impact on the country before they retire. And that means there will also be someone new with even rose-colored glasses or just excitement every 2 years rather than appointments happening very rarely. The impact, or why do we care? Because more judicial efficiency means that we'll be able to better enforce the Constitution, there'll be less backlogs, and we make sure that justice is not delayed. So here's a bonus AF argument idea, and I think a lot of more progressive states or circuits will read these arguments, and that is politics advantages. So you basically say that term limiting the justices will result in or prevent this good or bad thing from happening, or will prevent a bad thing from happening, or will cause a good thing to happen. So the uniqueness is you'll say that either the Supreme Court has ruled in a certain way, or will rule in a certain way, or won't rule in a certain way right now. And then you say that by term limiting the justices, we either increase the likelihood of a good ruling happening or we decrease the likelihood of a bad ruling happening. And then your impact is just why we care about that ruling. So popular examples will probably include abortion access, voting rights, LGBT rights, gun laws, climate change, and mostly it will be like liberal issues, because the idea will say we can only, get rid of this conservative supermajority by term limiting the justices. So most of these will be very liberal arguments, which is why I say that it might not work in more like traditional or conservative states with debate. So now that we've talked about all the different ways that you could affirm, let's talk about negative arguments or reasons why the Supreme Court should not be term limited. Personally, I think the affirmative arguments on this topic are stronger, but the structure of LD massively favors the negative, and the ability to defend alternative systems rather than the current working of the Supreme Court also will massively help you out. So the first idea of a negative argument is ageism. So that would be term limiting the justices is an ageist proposal and would harm protection of senior citizens. So ageism is discrimination against people based on age, usually referring to discriminating against older citizens. So right now, the Supreme Court justices are typically older individuals, and that also means that they usually rule in favor of protecting seniors when Supreme Court cases involving senior citizens pop up. But if you term limit the justices, most of the people who are doing it are basing it on ageism, saying that, that they're too old to have their opinions matter anymore, or to still be intelligent, or to still be able to make good decisions. And also, if you term limit the justices, there will be less representation of senior citizens on the court, and likely it will start being replaced by younger and younger people. The impact is that we will have more ageism, and that ageism results in discrimination, elder abuse, and human rights violations. Next, conflicts of interest. Term limiting the justices would cause them to rule in favor of whatever sets them up for success after retirement. So you say right now, Supreme Court justices know that they'll probably be on the court for their entire life, or they will retire when it no longer makes sense for them to have another job. However, if you term limit the justices, they will be leaving the court at a much earlier age, and they have to be concerned about, what do I do when this gig is over, like a lot of legislators do, which means that they'll probably end up ruling in cases in whichever way sets them up to have a job. So for example, right now, people in Congress will pass laws that are favorable to big corporations, and then all of a sudden they lose an election and find themselves on the board of directors of that corporation. So now what happens if a Supreme Court justice is seeing a case about a corporation, rules in favor of the corporation, so that when they're done with their 18 years, they are given a job there? It would create a conflict of interest because they have to be thinking about their future. And conflicts of interest are bad because they result in government corruption, they will result in bad rulings, and they would destroy the legitimacy of the court. Next, you have decreasing the experience and quality of the justices on the court. So the thesis of the argument is that term limiting the justices would make the court's judges less experienced and less qualified. So right now, court justices get decades of experience on different cases, and their nominations are taken really seriously because this person is going to be on the Supreme Court for the rest of their lives. But if you term limit the justices, you are going to make it so that the most experienced justice at any one time will still have less than 18 years of experience, rather than the decades of experience that the most seasoned judges have right now. That also means that when you have appointments happening every 2 years, it feels like less of a big deal. So we won't take it as seriously and will nominate less qualified justices. Why does that matter? Because justice quality will impact the quality of rulings, and the importance of rulings is that it enforces our Constitution and affects our citizens' rights. So we should have the highest quality people making those decisions. Next, we have docket manipulation. The thesis of the argument is that if you term limit the justices, they will improperly impact their decisions on which cases to hear and rule on at that time. So right now, if you're a court justice, you don't know when the court is going to change next. You don't know when somebody's going to retire. You don't know if someone's going to pass away, which means that you don't really factor who is about to join or who is about to leave the court into your decisions. But if you term limit the justices, you will know exactly who is leaving when, and you'll know what type of person is about to replace them, because we know that it's going to happen every first and third year. You'll know who the president is. You know who's been on the Supreme Court the longest. So that means that you might decide that if we know right now the Supreme Court is 5 liberal and 4 conservative, the conservative justices might try to prevent hearing a case until the next liberal justice leaves because they know the conservative one is joining them next, and vice versa. So it might impact what cases you choose to hear based on who is about to leave and who is about to join. But if you're manipulating the docket, that matters because the court will be even more political than neutral than it already is, and justice will be delayed or even fail to be delivered entirely because they're playing games with what cases they choose to hear. Fifth is doctrinal instability. Term limiting the justices will result in more rulings that overturn precedent back and forth. Precedent is essentially a ruling that established a law of the land that has existed for a long time. So when you have lifetime appointments, the court doesn't change very often, and when it does change, it changes very slowly. But if you term limit the justices, we're going to be changing the 9 people on the court to be brand new people every 18 years, and you're at least changing the court itself every 2 years, which increases the drive for people to rehear cases. So if the Supreme Court changes and the last time that they heard a case, it went away that the majority doesn't like, then the majority can be like, let's hear that case again, or let's hear a similar case, and then overturn what the previous people did. So precedent will get overturned over and over and over again to the point where there is no sacred precedent. And that matters because there will be legal whiplash where the laws are changing all the time. There will be political turmoil where it will really upset citizens and like change elections. And it also probably threatens human rights if the Supreme Court says, you have this right, no, you don't. You have this right, no, you don't, because it gets overturned over and over again. Next, you have gridlocking politicized confirmations. So the thesis of the argument is that if you term limit the justices, we'll have more frequent, more intense, and more failed confirmations in the Senate. So right now, confirmations of new justices are rare because of lifetime appointments. They don't happen all that often. But if you term limit the justices, you know that there's going to be a confirmation every 2 years. And these are super contentious because of how much power the Supreme Court has, which means that they're blocked all the time by the opposing party if they have the majority in the Senate. So if the president is liberal and the Senate is controlled by conservatives, then the conservatives have a motivation not to confirm a new Supreme Court nominee, hoping that the next president will be conservative so that they will have the power to, nominate someone that they agree with. That means that if the person on the first year of the president tries to nominate someone and they fail, that seat could be open for a long time. And then they might fail again in the third time, which means that the number of people on the Supreme Court could shrink very quickly if they aren't able to confirm someone every 2 years, which leaves seats open. It could lead to ties. So the confirmation hearings themselves are also pretty bad because every time there's confirmation hearings, we see more political polarization, we see less trust in the Supreme Court, we have more vacancies, we can't run other Senate business because they're too focused on the Supreme Court to actually help look at our laws and make new ones, and it means that there will be lots of tied votes and rulings, which is pretty bad. Next, we have judicial independence. If you term limit the justices, you will decrease their independence from the currently sitting executive officials. So most presidents get to nominate less than 4 justices while serving in office. Most will get to nominate 1 or 2. But if you term limit the justices, that means presidents who win 2 elections, so they're president for 8 years, are guaranteed to nominate 4 of the 9 justices on the court if you do the 18-year plan. And if you do the 12-year plan, they get to nominate 6 of the justices to the court, which gives them way too much power over the judicial branch. If there's supposed to be 3 branches to make them neutral and check back against each other, but one of the branches is controlled by the majority of the other 2 branches, then the Supreme Court will no longer be able to be a check on the Senate or on the president. But judicial independence is crucial to fighting corruption, checking abuses of power by the executive and the legislative branch. Next, you have politicizing the Supreme Court. So term limiting the justices would tie the Supreme Court to political trends rather than to the Constitution. Supreme Court officials are currently not elected by the voters, and they don't have to be afraid of losing re-election because they are not elected. So they also don't have to worry about being put on the Supreme Court a second time or about doing something that the public doesn't agree with, so they have the chance to lose their job. That means that they are more focused on the Constitution than on what the public is currently feeling, and you argue that that's a good thing. But if you term limit the justices, presidents and senators know that they'll get to be part of at least 2 confirmations, which means that presidents will start campaigning on, hey, when I'm president, these are the 2 people that I would put on the Supreme Court, which basically makes it so that now being on the Supreme Court is part of an election, and those people would be campaigning with the president who would nominate them, which seems pretty messed up. Senators would probably do the same thing. They're like, hey, this is how I would vote to confirm these people, yes or no, vote for me because I'll help get people on the Supreme Court, which means that the Supreme Court becomes inherently political when it's supposed to be neutral and apolitical. That basically turns justices into kind of elected officials. And the impact is that if they're not politically neutral, then they'll be more focused on their party than on the Constitution, or on respecting precedent, or on being independent, and that will hurt their legitimacy. The 9th negative argument is about preventing good court packing, which is essentially the opposite of the previous point for the affirmative, where you say that term limiting the justices would prevent or discourage Democrats from packing the court, which is actually a bad thing. So the status quo has a conservative supermajority. There are 6 more conservative judges and 3 more liberal judges, and that will likely persist for decades. If you term limit the justices, Biden or a future Democratic president probably can't or won't or would be discouraged from expanding the court to include more liberal justices to eliminate the conservative majority right now. It would take a long time for the majority to be overcome through a term limit, whereas court packing could be a more immediate solution that would no longer happen if we enact term limits. And then the impact is you just argue that the conservative supermajority threatens human rights, threatens the political neutrality of the court, makes election integrity bad, yada, yada, yada. So this is a more progressive liberal argument that I don't think would work in a lot of states. But if you live somewhere where people will listen to it, I think it's a good idea. And then lastly is you have term limits are unconstitutional. So you would argue that term limits would violate the Article 3 of the Constitution. So uniqueness, or right now, justices are given lifetime appointments based on the wording and the delineations between the Supreme and lower courts in Article 2 and Article 3 of the Constitution. But if you term limit the justices through either statutory law, you violate the Constitution, or if you change the Constitution to allow for term limits, you're trampling on precedent, you're trampling on the intentions of the founding fathers, a whole bunch of stuff about why the Constitution is sacred, essentially. The impact is that by violating the Constitution, we violate the oath of office for government officials. We open Pandora's box to have more violations of the Constitution or more changes to the Constitution, and it could even get the AF overturned by the Supreme Court. Is kind of a tricky argument that it's unconstitutional to the point where it would likely result in the law being taken away. Now that we've talked about the 10 main arguments for the negative side, let's talk about a bonus set of arguments. And these are counter proposals for ways that we could edit the Supreme Court that would likely be better, as you will argue, than term limits. So you say that term limiting the justices is not the best way or trades off with a better way to reform the Supreme Court. There are at least 10 different proposals that I've seen for how to fix the Supreme Court's problems that you could argue do a better job at solving for what the affirmative talks about, but avoid some of these 10 arguments we've talked about before. Mandatory retirement age says make it so that the Supreme Court justice has to step down when they turn 75 or when they turn 80 or when they turn 70, or set some sort of mandatory retirement age, which is very common in other countries. You have a expand or pack the courts to include more people counterplan. The balanced bench proposal basically says explicitly make the Supreme Court political, but then do your best to keep it neutral, where the conservative portion of the government gets to nominate 5 Supreme Court justices. The liberal portion of the government gets to nominate 5 liberal justices, and then those 10 individuals nominate 5 neutral people. So the 5 conservative justices that get selected and the 5 liberal justices that get selected also select 5 independents or 5 moderates or 5 people that are more in the middle to make a more balanced Supreme Court. So the Supreme Court would be expanded and it would be expressly political, but they would do their best to have a mixture of opinions. There's also the appellate lottery system, which says that instead of having a Supreme Court that is fixed, every single time something goes beyond an appellate court, you randomly select justices from the different circuit courts to create a Supreme Court for each individual case so that it changes, and that might make things more balanced. You have minimum age requirements in the same way that you have to be a certain age to become president or have to be a certain age to become, a member of Congress. You could set a minimum age requirement for the Supreme Court. You could do mandatory reconfirmation hearings where instead of a term limit, you just have to get reconfirmed by the Senate. So if a Supreme Court justice is past their prime or if a Supreme Court justice isn't doing a good job, then they might fail their reconfirmation, which is a way to get better justices on the court without having term limits. The dialogic approach is had in some countries where instead of the Supreme Court having actual power to overturn previous decisions and having power to take away laws or essentially like interpret the law, instead, whenever Congress or the president wants to do something, they run it through the Supreme Court and the Supreme Court tells them their opinion. Is this constitutional? Is it not constitutional? Does it violate precedent? Does it not violate precedent? And then they give the president or the legislative branch an opportunity to respond to either adapt or change or decide not to go for the law, but the Supreme Court doesn't have the power to overturn the decisions of the other two branches anymore. You also have jurisdiction stripping, which basically says the Supreme Court would have their ability to rule on certain cases or in certain areas of the law revoked. You have mandatory recusals, which says that if there's any conflict of interest, you should be able to force judges to recuse themselves or not be able to vote on a certain decision. And then lastly, confirmation hearing reform. We could change the way that the Senate votes to approve justices rather than implementing term limits. So all 10 of these are ways that people have proposed for fixing the Supreme Court that you could argue solve what the affirmative talks about, but doesn't cause the 10 arguments we mentioned before. Final thoughts. So now that we've discussed all of these different aspects of the topic, it's quite a large topic and I do actually really like it. So what do you need to keep in mind when you are debating and preparing for this topic? Well, first of all, this topic is huge. The affirmative, you really need to know what you will and what you won't defend. Even if you don't specify it in your first affirmative speech, knowing your vision of the topic so that you don't have to defend sketchy neg arguments is really important. Meanwhile, the negative, you need to try and figure out exactly what the affirmative's defending of the resolution so that you can tailor your arguments to match what they're doing, or so that you don't have your arguments taken away because they won't defend what you're talking about. Next, impacts are pretty rough on this topic. And impacts are really important because that's how judges usually decide the round, because they look at the impacts caused by each side viewed through the winning criterion to achieve the value. The problem with the impacts is, number one, they're not unique. Most of the impacts are already happening for both sides. People are going to talk about, oh no, the Supreme Court will be politicized. The Supreme Court is already politicized. Oh no, the Supreme Court won't be legitimate. The Supreme Court is already not legitimate. So a lot of these arguments are like principled, but they're principled arguments that are already being violated. So a lot of the bad stuff that people talk about is already happening. Additionally, there is a very little short-term effect of the resolution for bigger impacts. So if you choose not to apply the term limits to justices that are already sitting on the court, so if you say current justices, you get to have a lifetime appointment because that's what you were told when you agreed and you accepted your nomination, but new people, you're only going to be there for 18 years, it's going to take at least 18 years for us to see the impacts of adding these new rules in. So it's not going to have the backlash impacts and the principled impacts happen now, but changing who is on the court or how the court decides things or how many people are on the court, that will not happen for a long time. And then lastly, the impacts are very difficult to quantify and to specify. A lot of the literature just says that these things matter without saying why they matter or how they affect people. They're like, the Supreme Court cannot be political, but it doesn't say why. The Supreme Court has to be legitimate, but it doesn't say why. So you need to be able to explain why your impacts matter, how they happen, and who they affect. Lastly is we have the issue of framing. Framing is a wide open issue, and yet it's really important. Unlike the last two topics where it felt like it was pretty limited on what you could choose to value and the number of good criterions wasn't very big, this topic, there is no dominant or standout framing mechanism like there was on the last one. I think on the last one, most AFs eventually realized that the best strategy was to value justice with the criterion of minimizing structural violence. There is not one of those on this topic. There's so many different ways to do it. And yet, how you set up the round, how you define ought, how you define like what impacts matter the most through the criterion, how you decide the burdens of the affirmative with what they have to prove and what they don't have to prove is probably going to be the thing that decides a lot of different debate rounds. So understand that you need to be very good at defending your vision of what debate on this topic should look like. You need to be able to be ready to explain why you have the best ethical system for weighing decisions and why you have the best fair interpretation of what the goal of the affirmative and the negative is for the round through your burdens. With that, I hope that this was helpful for you, and I can't wait to see what the topic turns out to be. I think it's going to be a good one. Good luck in your tournaments, and I will see you in the next video.